The first question is that, do you really need to hire an immigration lawyer for your K-1 visa processing? The answer is it's actually your choice to hire an immigration lawyer. If you are new to my channel, my name is Jocelyn, and for today's topic, I'm going to discuss how to bring your fiancé to the US and how to start the K-1 visa process. The procedure and the requirements for the K-1 visa process is not that hard or difficult to follow. If you are able to follow each step, then you will be able to have the K-1 visa approved without hiring an immigration lawyer. However, the choice is yours. First, let's talk about the eligibility requirements. This is for the US petitioner and also for the fiancé who is located abroad. Please take note of the requirements before filing the petition for K-1 visa. Here are the eligibility requirements. First, the petitioner must be a US citizen and not a permanent resident. Also, the petitioner and fiancé must be legally free to marry at the time of filing the petition and thereafter. Also, the US citizen and foreign fiancé must meet in person within the last 2 years before filing the petition, except in cases of extreme hardship or if it is contrary to the culture of the fiancé to meet in person before marriage. Let's talk about the timeline when to file the petition. For example, you met on January 1st, 2022, and that's your first meeting in person. So you have actually 2 years. Within 2 years from the first meeting in person, or you have between January 1st, 2022 to January 1st, 2024 to file the petition. So if you file the petition before January 1st, 2024, it will still be in compliance within the 2 years requirement of filing the petition. However, after January 1st, 2024, if you file it, you are not eligible to file the petition. How long will the K-1 visa be processed? It depends on many factors. However, let me show you the process. There are actually several steps for the K-1 visa processing. Let's talk about step 1. The first step is for the US citizen to file the petition I-129F with the USCIS office that serves the area where petitioner lives. On your first meeting, please gather the documents or document everything on your first meeting. Gather all plane tickets and boarding pass. In addition, you must have a printed copy or copies of either mail, email, or chat messages to prove evidence of communication. In addition, you must also provide pictures, either pictures of the places you have visited together or pictures of yourselves during your first meeting. Also, pictures with family members are acceptable. Equally important are receipts and bank statements as evidence of your meeting together. So after the petition was filed and approved by the USCIS, it will be sent to the National Visa Center, and the NVC will give a case number and send petition to the US Embassy or consulate where the fiancé lives. Here is the step 2. Step 2 involves applying for a visa, and this is the procedure for the fiancé abroad. The National Visa Center will mail you a letter when it sends your fiancé case to the US Embassy or consulate. The fiancé must prepare the documents and be ready for interview. The interview date will be set by the US Embassy. Let's talk about the cost, where to file, and what to file for the petition. Expect the following fees to be paid when filing the petition 129F, which is the petition for alien fiancé. Currently, the fee is $535 for the petition. Also, the form DS-160 for the K visa applicant, which is $160. In addition, you must also pay the medical examination for each K visa applicant. Also, other costs may include translation and photocopying charges and fees, and also travel expenses to the U.S. Embassy or consulate for an interview. When you adjust your status, you will also have to pay the filing fee for Form I-485. The fiancé abroad must prepare the following documents. First, completed Form DS-160, which is the online non-immigrant visa application. You must also print the DS-160 confirmation page for your interview. Also, passport valid for travel for at least 6 months. Also, bring your birth certificate or divorce or death certificate of any previous spouse for both of you and the U.S. citizen sponsor. Also, police certificates from your present country and where you have lived for 6 months or more since age 16. Also, all K visa applicants must undergo medical examination, and you must provide evidence of financial support or provide Form I-134 or affidavit of support. Also, you must produce or submit 2 2x2 photographs and evidence of relationship with your U.S. citizen fiancé, and also the payment of fees. All K visa applicants must undergo medical examination and vaccination, and before you are issued an immigrant or K visa, every applicant must undergo medical examination, which must be performed by an authorized panel physician. You will be provided instructions regarding the medical examination. Also, all K visa applicants are encouraged to get the vaccinations required under U.S. immigration law. Although such vaccinations are not required for K visa issuance, they will be required when adjusting status to that of a legal permanent resident following your marriage. Let's talk about Step 3. This involves inspection at the port of entry. Like with all visas, a K-1 non-immigrant visa does not assure admission to the United States. A CBP officer at the port of entry will ultimately decide whether to admit your fiancé. Here is the Step 4. If your fiancé is admitted as a K-1 non-immigrant, you and your fiancé now have 90 days to get married to each other. Here is Step 5. This step involves adjustment of status. If you get married within 90 days, your fiancé or now your spouse can apply for the green card by filing Form I-485. The USCIS reviews the form and the rest of the documents your spouse submitted. If there are additional documents, they will request further proof. You and your spouse will generally be required to appear for an interview. If you are married for less than 2 years, the USCIS will grant your spouse conditional permanent resident status and issue a green card for 2 years. Now your spouse will need to remove the conditions on his or her residence by filing Form I-751, petition to remove conditions on residence in the 90 days before his or her green card expires. If you have any other questions or comments, please post them down below and I will get back to you as soon as I can. Thank you guys for supporting my channel, and if you haven't liked this video, please give it a big thumbs up, and if you haven't subscribed to my channel, please subscribe and hit that notification bell. I always welcome new subscribers. Thank you guys for watching. I hope everyone is staying safe and have a great day.